For 11 months, I slept on an air mattress in my daughter's guest room in Charleston. I want you to understand what that means, not the inconvenience of it, the weight of it. I am 80 years old. I spent 51 years in this country. I raised a family here. I practiced law here for 37 years. And at 79 years old, a man I had never done anything to decided that my home, a property I had owned outright, free and clear for 22 years, was something he could take from me through paperwork, pressure, and a process designed to exhaust people before they can fight back. He almost succeeded. I need to be honest with you about that part. He came very, very close. And I need to tell you what happened, because what they did to me, they have almost certainly done to someone else. What would you have done if you were 80 years old, if your health was not what it once was, if the legal system felt like a maze you were too tired to enter? What would you have done? Tell me in the comments, because I have thought about the answer to that question for a long time now. My name is Thomas Nguyen. I am 80 years old. I live in Savannah, Georgia, and I am still standing. Let me tell you who I am. I was born in HOA, Vietnam in 1945. I will not spend long on the war. You know the war. I arrived in the United States in April of 1979 with my wife Lynn, my daughter Mai, who was 6 years old, and 2 suitcases. We came through Camp Pendleton and spent 14 months in a church-sponsored resettlement program in Macon, Georgia. I want you to remember that detail. The church. It comes back. I had been a law student in Saigon before the fall. Here, I had to start over. I studied at Mercer University's School of Law. I graduated at 41 years old. I am not telling you this for admiration. I am telling you because what happened with this HOA cannot be understood unless you understand what I already knew about the way systems are used against people who have nowhere else to go. I spent 37 years as a civil rights attorney, the first 15 years in private practice, the last 22 as a regional counsel for the Department of Housing and Urban Development, HUD, handling Fair Housing Act enforcement cases. I investigated housing discrimination. I litigated it. I filed federal complaints on behalf of people who had been steered away from neighborhoods, denied mortgages, pushed out of communities by methods both blunt and surgical. I know what housing fraud looks like from 12 different angles. I am telling you this because Preston Whitfield had no idea what I used to do, and that is the only reason I won. My wife Lynn and I bought the house at 318 Palmetto Crescent Drive in Savannah in 2002. She passed away in 2017. I kept the house because she loved it. The garden she planted in the back, the way the live oaks draped over the porch in the morning. The property was 1.4 acres in a neighborhood called Magnolia Landing, a planned community of 87 homes with a homeowners association that had been, for most of our time there, unremarkable. Annual dues of $2,400, reasonable covenants, quarterly board meetings that I attended when my health permitted. I did not cause problems. I did not receive complaints. I want you to remember that number, 87 homes. It matters later. Preston Whitfield moved into Magnolia Landing in 2019. He is 58 years old. He owns a real estate development company called Whitfield Properties Group, which operates primarily in coastal Georgia and South Carolina. He is broad-shouldered and tan, in the way of someone who spends a great deal of time on boats. He speaks with the specific confidence of a man who has never been told no by anyone who mattered to him. He became HOA president 18 months after moving in January of 2021. after the previous president, a quiet retired school principal named Gerald Watts, resigned abruptly for reasons that were never fully explained to the community. I want you to remember Gerald Watts. He comes back. The first time I met Preston Whitfield one-on-one was at my front door in March of 2021. I had received a notice 3 weeks earlier citing me for an architectural violation, specifically a pergola I had built in the backyard in 2015. The notice stated that the pergola had never received Architectural Review Committee approval and was subject to a fine of $500 per month until remediated. I had, of course, submitted the approval request in 2015 and received written confirmation. I had the paper, but I was curious about the visit, so I answered the door. He was wearing a polo shirt and holding a clipboard. He smiled with all his teeth. He said he was just coming by personally to make sure there were no hard feelings. That was his phrase, no hard feelings, as if I had done something wrong, as if the notice was a mutual inconvenience rather than a demand based on a false record. I asked him to show me where in the HOA records my 2015 approval request had been rejected or had not been received. He said the records prior to the 2021 board transition were incomplete. He said it with a shrug. I looked at him for a moment, and then he said something I have not forgotten. "Mr. Nagian, at your age you really should be thinking about simplifying your life." I did not say anything. I thanked him for coming by and closed the door, but I walked directly to my filing cabinet, pulled out the folder I keep for every HOA matter, and wrote down the date, the time, and his exact words. I have been writing things down for 50 years. When things feel wrong, you document them. You do not know yet what you are building, but you build it anyway. And that was just the beginning, because what came next made that visit look like a courtesy call. The pergola fine was $500 per month beginning April 2021. By June, they had added a second citation: improper storage of yard equipment visible from the street. My lawnmower was in my backyard behind a 6-foot privacy fence. By August, they had filed a third: failure to maintain the front pathway to HOA standards. I had repaved that path in 2019. I have the invoice. By October, the cumulative fines on my account were $6,200. And then, on November 3, 2021, I received a letter from the HOA's attorney stating that Magnolia Landing HOA intended to file a lien on my property at 318 Palmetto Crescent Drive for unpaid assessments and fines totaling $8,400. I want you to understand what's on the line here. My house was not mortgaged. I paid it off in full in 2009. The appraised value in 2021 was $740,000. What they were doing, what a lien does, is this: it attaches to your title like a parasite. You cannot sell. You cannot refinance. You cannot transfer the property without satisfying the lien first. And if the lien goes unpaid long enough and the HOA is aggressive enough, they can initiate foreclosure proceedings. In Georgia, under the Georgia Property Owners Association Act, an HOA can foreclose on a lien if it meets certain statutory thresholds. I knew this. I had seen it done. I had seen elderly homeowners lose properties that had been in their families for generations because they did not understand the mechanism being used against them. I was not going to be one of those people, but I was also beginning to understand that this was not a dispute about a pergola. I called Beverly Okafor in December of 2021. Beverly is 61 years old and has been practicing fair housing and housing rights law in Atlanta for 33 years. We had worked on the same HUD task force in 2008 during the foreclosure crisis. She is methodical and dry-humored and does not waste words. The first thing she said when I described the situation was, "Thomas, pull every HOA board meeting minute from 2019 forward, every single one. Not the financial statements, not the CC&Rs, the minutes." I did not know yet exactly why she wanted them, but I had them requested and in my hands within a week. But I was not ready for what I found when I actually read them. In February 2022, Beverly drove down from Atlanta and we sat at my kitchen table for 4 hours. She brought a yellow legal pad and I had the folder. The thick one, the kind I used to bring to federal hearings, accordion pleated with labeled tabs. The motif of my entire legal career, the folder. Lynn used to say I was not truly confident about anything until there was a folder. Beverly went through the board meeting minutes from January 2021 forward. What she found was not immediately obvious. It was in what was missing. In 12 months of board meetings, 24 sessions total, there was not a single vote recorded on any new architectural citation, any new fine, or any lien authorization. Not one. The decisions being handed to homeowners as official HOA actions had never been voted on by the full board. They had been issued unilaterally, without quorum, without proper notice, and in direct violation of the HOA's own governing documents, which required a majority vote of the 5-member board to authorize any fine above $250 or any lien filing. I want you to sit with that. The lien on my home, the legal instrument they were using to threaten foreclosure on a property I had owned free and clear for 22 years, had never been authorized by a legitimate board vote. It was, in Beverly's precise and careful language, void on its face. That was the first smoking gun. The second was uglier. Beverly had also pulled the Chatham County property records for every property in Magnolia Landing that had received a lien notice from the HOA since 2021. There were 11 of them. I want you to remember that number. 11 homeowners who had received HOA liens in the same 18-month window. Beverly cross-referenced those 11 addresses with a separate database she maintains of real estate transactions in coastal Georgia. And here is what she found. 5 of those 11 properties had been sold within 6 months of the lien being placed. In each case, the sale price was below market value. In 4 of the 5 cases, the buyer, through one LLC or another, traced back to Whitfield Properties Group. Preston Whitfield had been using the HOA he controlled as an instrument to depress property values and force distressed sales. He would manufacture violations, issue unauthorized liens, create the appearance of financial and legal jeopardy, and then, when homeowners were frightened enough or tired enough, acquire the properties at a discount. And here's the part you need to write down. Under the Fair Housing Act, specifically 42 U.S.C., paragraph 3604, it is illegal to use discriminatory practices to interfere with a person's enjoyment of their dwelling or to coerce them into selling their property. When Beverly looked at the demographics of all 11 homeowners who had received liens, 9 of them were over the age of 70. 7 were people of color. In federal fair housing law, that pattern has a name. It is called targeting, and I'd spent 22 years of my career prosecuting people who did exactly this. Here is the knowledge nugget I want you to carry out of this story. The Fair Housing Act does not only protect you from being denied a loan or steered away from a neighborhood, it also protects you from being pushed out of a property you already own. Age is not a protected class under the Federal Fair Housing Act, but race and national origin are. And if a pattern of conduct can be shown to have a disparate and adverse impact on protected classes, The legal standard is met regardless of whether the perpetrator said a single discriminatory word out loud. The pattern is the proof. Document everything, because the pattern becomes visible when you lay it flat on a table. We filed a formal complaint with HUD's Office of Fair Housing and Equal Opportunity on March 14, 2022. I will not pretend that was not a strange thing for me. I spent 22 years on the other side of that desk. But I filled out the complaint form in Beverly's handwriting and added my signature, and felt something I had not felt in a long time. Useful. Now, I need to tell you what happened next, because this is the part that still makes me slow my breathing when I think about it. 11 days after we filed the HUD complaint, Whitfield moved to accelerate the foreclosure proceedings. He did not delay. He escalated. I received notice on March 25, 2022, that Magnolia Landing HOA had filed in Chatham County Superior Court to foreclose on the lien and initiate a forced sale of 318 Palmetto Crescent Drive. The court date was set for June 8th. That was 11 weeks. Beverly called me that evening and she said, "Thomas, this is a pressure move. He wants you to settle before HUD can move." I already knew that. I had done this for 37 years. I knew what pressure moves looked like, but I also want to be honest with you. That night, sitting in my chair in the living room where Lynn used to read, looking at the photograph on the side table, the one I've had since 1983, my family in front of the first house we ever owned in America, laminated at the edges because I have moved it and touched it so many times, I felt something I had not felt in a long time. I felt afraid, not of Preston Whitfield, of time. I am 80 years old. My knees ache. My memory is still sharp, but my body is slower than it was. And I sat there and I thought, do I have enough left for this? Have you ever had someone try to take the last place that still feels like you? Not just a property, not just an investment. The place where your wife's garden still grows in the spring? Because that is what was happening. And I need you to know that even at 80 years old, even with 37 years of legal experience, the question was real. I want you to remember what the answer was. I called Beverly at 7 the next morning and I said, "We are not settling. Tell me what we need." What we needed came from Gerald Watts. Gerald was the HOA president before Whitfield, the retired school principal who had resigned abruptly in early 2021. Beverly tracked him down through a mutual contact. He was living quietly in a senior community in Brunswick, Georgia, 30 miles south of Savannah. He agreed to meet us in April. He was 74 years old, soft-spoken, and visibly relieved to have been found. He had resigned, he told us, because Whitfield had presented him with a document in December 2020. A document that purported to show that Gerald had misappropriated HOA funds, approximately $12,000 from the reserve account, over a period of 18 months. The document was fabricated. Gerald knew it was fabricated, but he was 74. He had no lawyer, and Whitfield had told him quietly that if he resigned immediately and said nothing, the document would remain private. If he did not resign, Whitfield would file a criminal complaint. That is called extortion. It is also called witness tampering, which becomes relevant when the person doing it is the subject of an active federal housing complaint. Beverly had everything she needed: the unauthorized lien, the fabricated financial record used to remove an obstruction, the 5 below-market acquisitions, the demographic pattern, the acceleration of foreclosure timed to precede the federal complaint resolution, She filed for an emergency injunction in federal district court to halt the Chatham County foreclosure proceedings. She got it. The June 8th court date was stayed. Beverly then formally amended the Hood complaint to include the extortion of Gerald Watts, making it a referral for criminal investigation. I want to be precise about what happened next. I want to be careful because there are proceedings still ongoing, and I am not going to say more than I can say. What I can tell you is this. On September 19, 2022, the United States District Court for the Southern District of Georgia entered judgment in favor of the plaintiffs, myself and 6 other homeowners who had joined the action, finding that Magnolia Landing HOA, under Preston Whitfield's leadership, had engaged in a pattern of conduct constituting unlawful interference with housing rights under 42 U.S.C. Paragraph 30, Texas 4. The unauthorized liens were voided. All fines issued without proper board authorization were vacated. The HOA was ordered to pay $214,000 in compensatory damages distributed among the 7 plaintiffs. My share was $41,000. Preston Whitfield resigned from the HOA board 4 days before the federal judgment was entered. I heard from Beverly that he hired a new attorney shortly after, a criminal defense attorney. I will leave the rest of that to the appropriate authorities. I walked into the courtroom that morning wearing the same dark suit I wore to my first federal hearing in 1986. Beverly sat beside me. Gerald Watts was in the gallery. And when the judgment was read, I looked across the room at Preston Whitfield. He was looking at his hands. He did not look up. I did not need him to. He was right. I had been thinking about simplifying my life. I simplified his considerably. I moved back into 318 Palmetto Crescent Drive on October 4th, 2022. My daughter, Mai, had driven up from Charleston to help me carry things in. It did not take long. I had not unpacked much from the air mattress room. The last box I brought in was the one with the photograph, my family in 1983, laminated at the edges. And I set it back on the side table where it belongs, in the room where Lynn used to read. That is where it still is today. Now let me tell you what I want you to take from this. Not the victory, the preparation. I won this case not because I am a lawyer. I won it because for 40 years I have had a habit. When something feels wrong, you write it down. The date, the time, the exact words. I wrote down what Preston Whitfield said to me at my front door in March of 2021. That documentation, combined with 12 months of board meeting minutes, combined with county property records, combined with Beverly's pattern analysis, that was the case. No single document was enough. The pattern was everything. Your name on a deed is not symbolic. It is a legal ownership interest. No HOA, none, can file a valid lien against your property without proper authorization from a legally constituted board following the procedures in their own governing documents. If you receive an HOA lien, the first thing you do is request, in writing, the board resolution authorizing it. Under most state HOA statutes, that authorization must exist. If they cannot produce it, the lien may be challengeable on its face. Do not pay first and ask questions later. Ask questions first, always. And if the pattern of enforcement in your community seems to fall disproportionately on older residents or residents of a particular background, document it. Pull your county records. Find out who has been cited. Find out who sold. Because what looks like aggressive code enforcement often has a different name in federal law. My name is Thomas Nguyen. I am 80 years old. I came to this country in 1979 with 2 suitcases. I spent 51 years building something here, case by case, home by home, document by document. And when a man in a polo shirt looked at me and saw someone he could push out, he found out that the folder was full. I am still right here at 318 Palmetto Crescent Drive in Savannah, Georgia. I am still standing, and I am not going anywhere.